My dear beloved brother, Dr. V.R. Sampath, founder and editor of Sattakadir, President of Madras Development Society, Honorable State Law Minister Raghupati, Honorable Minister Justice Kalayarasan, Chairman State Language Commission, Honorable Mr. Justice Durai Karnagaran, former Chief Justice of Seychelles, Honorable Vice Chancellor of Tamil Nadu Dr. Ambedkar Law University, Dr. Santosh Kumar, Learned Senior Advocate, Member Bar Council of Tamil Nadu and Puducherry, and former Advocate General, my beloved brother Thiru R. Vidudalai, Learned Senior Advocate, Vice Chairman, Bar Council of India, and President Tamil Nadu Advocates Association, my beloved brother Thiru S. Prabhakaran, Learned Senior Advocate Thiru A. Tyagarajan, Mrs. Shantakumari, Advocate and former President, Women's Lawyer Association, Mrs. Nalini, Advocate and former President, Women's Lawyer Association, Professor Anand Mishra, Director Jindal Global Law School, Professor and Dr. Muthuvel, Member, State Language Commission, and the other judges, academicians, advocates, and other learned members present over here in this virtual global conference. Good evening, one and all. It is a wonderful program organized by Dr. V.R. Sampath on the topic Law and Justice. It is a 29th Sattakadir Global Conference. I take the privilege of addressing and throwing light on the specific area of mediation and its importance in justice delivery system. We all know that our judicial system starts from the lower judiciary, from taluk level courts to district level courts, and then High Court in various states and Supreme Court of India. We all might have had a dispute with someone at some point of time in our own life. Either it might be within our family members, friends, workplace, business, or neighbor, or unknown. The root cause for any differences or conflict or dispute arises out of ego, jealous, competition, misunderstanding, or through any miscommunication, and in some cases, it is often due to the decisions taken out of emotions rather than based on reason. Peace cannot be kept by force. It can only be achieved on understanding, said Albert Einstein. In litigation, one wins and the other loses because the matter are decided and not settled. Therefore, it is always better to go for mediation and arrive at a settlement. Settlement is nothing but a compromise or agreement between the litigants to settle the matters in dispute between them in order to dispose of and conclude the litigation. The litigants, those who approach the court, come with a lot of expectation that he will get relief soon. But the reality is he need to undergo pain and mental depression, wherein the civil and criminal disputes would take nearly 1 or 2 decades. In some cases, the next generation of the litigant will be continuing in contesting the cases for further more years. Because of the delay in civil dispute, it leads to take law into their own hands and giving way to criminal dispute as per the advice of the litigant's advocate. And the parties will have to break the relationship and end up in enmity, thereby no chance for bonding between them at any point of time. Unfortunately, our procedural law and the system in our judiciary causes inordinate delay, leading to number of pendency in cases, and the amount spent during the process in litigation is high, and the access to justice is difficult to the poor. Reasons are many. As per the data available in the website of the Supreme Court of India, 70,000 cases are pending, and the strength of judges in Supreme Court is only 33 presently. In India, it is like demand and supply. The Nibbana part is we need expansion of the courts with proper infrastructure in the courts with all necessary setup and filling of judicial vacancy as said by the senior Mr. Vidudalai from the top to bottom levels of courts in an efficient manner by giving proper training at the entry level of the lower judiciary. The lack of proper judicial training in the lower judiciary amounts to multiplication of cases to be appealed before the higher courts. In many occasions, the judiciary and the government, both state and the union, does not go together. If this gets smoothened, then the appointments and the fund allocation for betterment of infrastructure would also improve better. The supply part is we are having 402 lakh cases which is pending before the district and taluk level courts, out of which 107 lakh are civil cases and 295 lakh cases are criminal cases. Pendency cases are like endemic problem in India. The another issue is participation of advocates in conducting the cases. When the judges are ready, the advocates may not be well prepared to contest they simply seek adjournments, and the other one is participation of the parties in conducting the cases. The party to the litigation has two options. One is to seek the court and other one is alternative dispute resolution. The alternative dispute resolution may be arbitration, mediation, and conciliation. Arbitration is a formal way of procedure. The mediation is a practice through which the conflict between the parties are reduced and the differences are arrived at an amicable solution. The mediators, they put their effort in arriving the settlement. It is completely different from arbitration. Mediators shall be a neutral to the mediation. Indian has brought arbitration law which has not achieved the targeted purpose. There is a popular story. Some years ago, a man indigently paraded up and down every day outside the British Royal Court in London, carrying two boats on his shoulders, one is in the back and front. Said, arbitrate, don't litigate. But one day he disappeared. It was said that it was not due to natural cause, but because he had come to realize that there was really no more difference between litigation and arbitration. While many countries have chosen mediation legally, India started a bit late. India enacted an Arbitration Act in 1996. Mediation is mandatory under the Civil Procedure Code of India. Many mediation institutions are existing and thriving. The Delhi and Bangalore mediation centers have successfully mediated 39,000 cases in 2 months, lightening a part of huge backlog of 31 lakh cases in the courts. Sri Lanka has enacted a Mediation Board Act and set up mediation commissions. The courts very often refer cases to the commissions for settlement by use of mediation. The rate of success is really high. Singapore set up its mediation center in 1997. Mediation has become a part of Singapore legal system. Mediation is widely and successfully used in Singapore. Dubai also created a mediation center which has successfully mediated about 1/3 of the pending cases in the Dubai court in a very short period of 1 month. The French Civil Procedure Code sets forth that a part of function of a judge is to conciliate the parties. In recent years, the French courts have rather often settled disputes by mediation with a high rate of success. Mediation is a very old system in our Indian culture. I can mention in one line about our Indian epic story Mahabharatam, which was a rival between two families, and it was mediated by Lord Krishna. The mediator would encourage and facilitate the parties to arrive at a solution. In mediation, it will be a win-win situation for both the parties, but in litigation, one party wins and the other loses. Always, the loser will have the option to choose for appeal. Few days back, the draft mediation bill 2021 was released on 29th October, welcoming the suggestions and inputs from stakeholders, which is a welcoming and positive move. I would like to mention few sections here, wherein section 20 states the time limit for completion of a mediation, which shall be 90 days from the date of commencement. Section 6 refers to pre-litigation of mediation and settlement. Section 22 refers to confidentiality of cases will be maintained in mediation. Section 30 refers to the entire expenses shall be borne by both the parties equally in mediation, including the mediator fees. In this bill, there is no definition or clarity given who can be a mediator, whether the advocate has to undergo certified training to become a mediator, or any individual, either non-advocate, can get trained and become a mediator. The Mediation Council has to decide upon this issue. The training institute should properly train the mediator with all the skills required to be a qualified mediator by teaching them psychology, body language, reading the human rights, and all other skills required to be a qualified and professional mediator, as it is completely different from arbitration and judging a case as a judge. Mediation, before you learn how to mediate, you must unlearn what you think mediation might be. The draft mediation bill should be read from that perspective. We need to take this further, as many countries like US, United Kingdom, Australia consider mediation seriously. This tool is utilized by the litigant effectively, as it is mandatory option before they choose for litigation. Pre-litigation will be a great move for our country if it is made as a mandatory option, which will definitely reduce the volume of pendency of cases. But our advocate mindset is more important, that they should be willing for the change to happen and get trained in this field to become a professional mediator. In many court annex mediation, the mediation fails for the reason that the mediators are not properly trained and they could not conduct effectively. Advocates and general public should be given awareness about the mediation, and the advocates should encourage the parties to try mediation before approaching the courts. Our former Chief Justice of India, Honorable Justice Bob Day, in his speech in Bar Council of India held in 2020 before the pandemic, insisted the Bar Council of India to add the subject mediation to the law students in the curriculum. And the present chairman and vice chairman of Bar Council of India also took steps, but it has slowed down because of this pandemic. I request my learned brother, Mr. Prabhakaran, Vice Chairman of Bar Council of India, to take further steps to include mediation as a separate subject to all the legal education centers, along with the practical training hours. Our present Chief Justice of India, Honorable Justice N.V. Ramana, in the recently held India-Singapore Mediation Summit, has addressed, stating that mediation is the need of the hour, and time has come to bring mediation as a mandatory first step to dispute resolution. Mediation will be the better tool to reduce the backlog of pending cases in our country, and all other developed countries choose mediation, and they have less number of cases pending in the respective courts compared to our country. We all would have come across this legal maxim, that is, justice delayed is justice denied. By trying mediation, we can get justice in a shorter period of time. I would like to mention few quotes by great people about mediation. Dalai Lama said, "There are many people in the world, but relatively few with whom we interact, and even fewer who cause us problems." So when you come across such a chance for practicing patience and tolerance, you should treat it with gratitude. It is rare, just as having found a treasure in your own house. You should be happy and grateful to your enemy for providing that precious opportunity. This is precisely the role mediators play in one's life. The Bible says, "Blessed are the peacemakers, they shall be called children of God." I conclude with the preamble of our Constitution, which mentions the provisions of justice shall be to each and every citizen of the country. Mediation shall be the better and vital tool to provide justice to each and every individual of the country. The poor may not be able to shell out huge money and time to get justice. Though we have lok adalats, it needs to be streamlined in a proper manner. Let us all encourage mediation and use it effectively to reduce the pendency of cases in our country. I thank Dr. V.R. Sampath for having given me a chance to share my views on this mediation. I thank you one and all.